Well, as I look at my clock, I don't quite have 12 o'clock yet, so that means that we may not have everybody here. So I'll have a little bit of a stretch out of introductions and say, hi out there. We'd like to welcome you to our program for today. And I am Marcia Getting, but I should first tell you the topic. And the topic that we're going to be talking about this morning is looking at what you can do with a will and what you can't do with a will. And sometimes there's a lot of misperceptions out there that people have that, well, once I've written my will, then everything that I own is going to be distributed by that will. And that is not necessarily true. And that's why I like to sort of coordinate what's happening with a will and how you have your property titled. And that's what we're going to be taking a look at. My name is Marcia Getting, and I'm the Family Economics Specialist for Montana State University Extension. And Extension is the outreach group that is out in the communities. We're taking the university to the people. Not everybody can just up and move to Bozeman if they want to get some education. So Extension's out there in a lot of areas: agriculture, community development, youth programs, and family and consumer sciences. So sometime go to the website for just Montana Extension and you'll just be amazed at all the information that is out there. And our co-host for this morning is Mandy Reed. And I really must give Mandy credit because she's the one that came up with the idea. Marcia, we need to do a program for parents with minor children. So we put our heads together and came up with topics that we thought you'd be interested in. And then we've also involved some additional folks. And those additional folks actually are our special guests today. We're going to have Kimberly Richardson join us, and she is from Ravalli County. So if you're ever down in Hamilton, you can yell at her and say hello. And then we also have Wendy Weedham. Wendy happens to be in Pend Oreille County, and she's the Family and Consumer Science as well as 4-H agent there. And I've visited her several times in Conrad, Montana. We would like to welcome, we had 59 registrations from Montana, and you can get an idea of where people are joining us from. And I see a whole bunch of stars there that must be Gallatin County or Bozeman. But as you can see, our participants are all over the state. And, you know, that's really kind of exciting because this way we have the opportunity to really spread out. And if Mandy and I were traveling from county to county, oh my, you know, it would take us a long time to reach all of those locations. And then we even have 9 out-of-staters. So this makes us feel somewhat famous if we've got folks from out there. And I guess I would like to give a special shout out to great grandma and great grandpa Rod and great grandma Vicky out of Oregon that indicated that they're watching what I'm calling now our show, but it's also our presentation. So Mandy, why don't you tell us about some of the participant engagement tools that we want to use to keep everybody interested in our program today and also keep them awake, right?
Yeah, absolutely. So we want to make sure that even though we can't all be together in the same room or the same space, that we give an opportunity for all of you to engage in our webinar today. So I'm going to go over our top 3 participant engagement tools that we're going to be using today. So our first one is our chat room. So I don't know if you saw in the introductory video, but you can click on the right-hand side of your screen, the chat box, and you can put questions in there, questions for us or answers to questions that we might have for you. So we really encourage you guys to use this. We learned in our last one that people weren't participating in the chats as much. And so we would like to do a test today. So please go to the chat room and let us know how you're joining us today. Are you joining us on your computer? Are you joining us on your cell phone? So go ahead and jump on the chat room there and put your answers in, and we'll just give you a minute to do that. So, and if you just joined us, I've asked everyone to put in the chat box how how they're joining the presentation today. Are you using your cell phone? Are you using your computer? So while everybody's doing that, we'll go ahead and move on, but please do that so then we know a little bit more about you. So after the webinar, we will be remaining open on the WebEx to answer your questions, and we'll have a panel as well as Marcia and myself. And so you can also put those questions in the chat room, and then we'll be able to answer those for you. So our next engagement tool are poll questions. So we're going to ask questions, and then you have the opportunity to answer those questions. So we'll try one out right now. So Carrie's going to put that poll up for us. And our poll question is, as a result of last week's webinar, what action, if any, did you take? So did you try out the Dying Without a Will website? Oh, and you can mark more than one of these. So if you did several things, you can go ahead and click on several boxes. Did you request the CD, Dying Without a Will? Did you discuss with your partner or husband or spouse about getting, about who should be the guardian or conservator for your minor children? Did you read the Mont guides about estate planning for minor children? Did you read the Mont guide about the UTMA, or did you do something else? And if you did something else as a result of last week's webinar, you can put that in the chat room. So we'll go ahead and give you the opportunity to answer these poll questions.
Yeah, and I should say, Mandy, I was shortening that up. UTMA is the thing, and it's the Uniform Transfers to Minors Act. And that's what Montana's under when we're doing gifts to minors, if you want to do that and have a custodian. So don't forget, hit submit.
All right. Oh, yes. And like Marcia said, after you get your answers in there, go ahead and hit submit, and that lets us know, that makes sure that your answers count. All right. So it looks like a few of you tried out the website, so that is excellent. And a few of you had that very important conversation, so thank you for doing that. That is excellent. And a few of you checked in and read the Mont guides. So good work. Good work, team. That's awesome to take those action steps. So the next engagement tool that we have is courtesy of Marcia's great talent that she shares with us. She is passionate about wildflowers, and not only is she passionate about just finding them, she's also very passionate about photographing them, and has developed quite a skill. And so she goes out all over and seeks out these beautiful wildflowers, and she's uses them in her webinars, and so we get to enjoy them, and they're also help us remember the key points. And so what a great memory trigger we have in those awesome wildflowers. So Marcia, would you lead our participants into the information about wills?
Oh, I don't know if I want to lead people, but I might steer people. Ha ha ha. Did you get it, folks? Yeah, my husband was walking through here the other day when Mandy and I were practicing, and he saw these little cloud things with words, and he said, "You're doing cartoons?" No, this is a way for Mandy and I to remind one another, when's your time on? So yeah, I want to steer you to important information about wills. Okay, and then I think you'll be really excited about this. I'm going to steer you to free will forms that are available from our very own Montana Legal Developer Program. So stay tuned for that. Now, we know out there that there's people don't write wills. I mean, we don't want to deal with death. There's lots of reasons people don't write wills, but when you have 7 out of 10, it's a serious concern, because then what you do is you're turning it over to the legislature to say what should happen with your property, and that may not be what you want. So to represent wills, what I'm going to use are bane berries. Okay, so emphasize that bane. And if you know baneberries, you've seen the pretty flowers, but then they make these marvelous berries. And so it made me think about a phrase that I've heard. So people will say, well, so-and-so is the bane of my existence. I even had one guy at one of my meetings one time, and he came up and he said, you're the bane of my existence. Yeah. Well, what he was trying to convey in a different type of way is that he and his wife had been doing estate planning. And he said, that's why you became the bane, because she was constantly saying, Marcia said this, Marcia said that. So that also then made me feel good. So we all know about a will. It's just a written document that talks about how we want to have our property distributed after we're gone. And oh, speaking of that, that makes me think of a trivia question, because that's one thing I like to do is give people the opportunity to have some of my cards. I've got a lot of them, and during COVID, I have folded and made a zillion note cards. So here's the question for the day. Speaking of wills, what is the meaning of the word testator? So what you do is enter that in the chat room, and the first person that gets it right is the one that's going to receive one of the note cards. And Carrie's going to keep an eye out on that and be able to tell who was able to do it because of the time factor that's in there. Now, Mandy, how about you ask our first question about wills?
All right. So our first poll question is, does a will have to go through probate to be declared valid? So this is a pretty easy one, just a yes or no. So go ahead and put your answer in there, and then remember to hit submit so that we can see that. All right, so thank you to everybody that answered. And a lot of times people say no, and I see that we have a pretty good split between yes and no. So that's why we like to ask this question. But in fact, a written will does have to be validated through the probate process. It's not valid until the court says that it is. So our life insurance and things like that with a beneficiary are going to not be in probate, but then our will be validated through probate. So Montana has some requirements. So the first requirement is you have to be 18 years old or more to have a will.
I used to do this at my estate plannings, Mandy. I would look at people out there, and then I make a quip in my mind is white hair. And most of the people that attend a meeting are a little bit on the older side, because now we realize, hey, we could die someday, I guess. But we don't think about that when we're young.
It's true. All right, another requirement is that you have to be of a sound mind. So you have to know the nature of your property, and you also have to know who you want to give your property to. So you need to name your children in your will. So an example of a will is being of sound mind. I've spent it all. I know we've all heard that. We're going to spend it all. And wouldn't that be great if we had that opportunity? Another requirement is that you can't be under undue influence. So they're not necessarily referring to undue influence of alcohol, but they're referring to undue influence of other people also. You can't be pressured into writing your will a certain way. So they want to make sure that it is really your intention and that you haven't been harassed or bullied. So holographic wills are legal in Montana. They do require a signature, and they have to be handwritten by the testator. So, but there's no witnesses are necessary for this type of will. But it is very key that they have to be handwritten. So we have another poll question for you. A Montana man wrote a will on motel stationery in his own handwriting. Was that will considered valid? So you can answer that poll question and then hit submit when you're ready. We'll just wait for those results to come up. So, so the judge actually interpreted that this will was not valid because they rejected the will because the stationery had the motel or hotel logo and address on it. So those things were not in the handwriting of the testator, and so they rejected this will and said it wasn't valid. So I'm curious, what do you guys think about that? And you can put that in the chat. I was pretty surprised to hear this story myself, but it also made me realize how important it is to know exactly how to make sure that we write our will so that our wishes are honored.
Yeah, and that's where, you can run into trouble. You just think, well, it makes sense to me, and it made sense to that gentleman, I'm sure. And who would have anticipated that something like that would have been rejected? So as I told Mandy, it's okay to do a holographic will. And usually when I get a call, it's usually from someone that says, can I handwrite my will? And I say, yes, but. And I find, oh, these people before COVID were going overseas, they were doing other things and traveling, and they wanted to make sure they named guardianship and conservatorship for the children, which we talked about last week, the importance of doing such.
Yeah. So it's important to make sure that we recognize that. And one of the things I didn't mention is that a typed will has to have a witness, but a handwritten will does not have to have a witness.
Oh, two witnesses, Mandy.
Two witnesses, thank you. And
we got to have two.
And then also something else to consider, the fill in the blank wills are considered typed, even though you're handwriting on them also, and they also have to have two witnesses. So just some things to consider. All right, so I have another trivia question for you. What is the meaning of the word, and I've practiced it so many times,
Devizee.
Devizee.
Well, that's how I've been saying it's Devizee when I finally heard it. But okay, Devizee. Yeah, sounds French, doesn't it, to me? So you're going to enter that in the chat room, right?
Yep. So please enter that answer in the chat room. And this is a trivia question. So the first person to answer that correctly is going to win a card from Marcia. So go ahead and put your answers in the chat room. And while you're doing that, we could go ahead and move on. So what happens if you write a will and you need to change it? Things happen in our lives and sometimes we need to change some things. So you can revoke the will entirely and make an entirely new will, or you can add a codicil to the present will. So you can just add some changes to it. People would more likely write a new will when things changed, but you can also add the codicil and then you need to have that witnessed also that you've signed that. So a lot of times people have questions about their children in wills, especially grown children. And a common question is, do I have to leave at least $1 to each child? And the answer to that is no. But you do need to make sure that you recognize in your will that you do need to recognize all of your children in the will so that the will reflects that you understand, that you know the number of children that you have and that you haven't just inadvertently forgotten one of them to include them in the will. So you need to recognize them, and there might have been an agreement that maybe in this case, maybe the two girls got down payments for their homes when they were younger as part of their inheritance, and they've already received that because they've already bought their homes. And so that gift isn't part of the will, but you do need to recognize it in the will that they have already received their gifts so that they can't say, well, dad forgot that I was, dad or mom just forgot me. They really meant me to be here. So Marcia, what happens in the case of a divorce?
Oh boy, that can get a little bit sticky. Just imagine this situation. Here we have John and Millie, And we discover that he's leaving part of his estate to her, and it's going to be 150,000. But we discovered they're divorced. So we've got a situation. Going to say that John dies. Okay, and what we want to do is figure out who's going to receive that $150,000. Is it going to be Millie, his former wife, because she is specific, well, no, she's mentioned as his wife in the will. We've got Sarah. See, now Sarah is his present wife. Then we've got his 3 minor children, and we've got John's parents. So who do you think is going to receive that $150,000 of John's estate? So find your answer and then make sure that you click submit. This is something I was always forgetting to do, but we want to make sure that your answer counts. So Millie, Sarah, the kids, the parents of John. And I could have even said Montana, but I didn't figure anybody'd say that. All right, so Carrie's already calculated this magically, and we're seeing that 52% of you are saying that it's Millie. Oh, nobody thinks that Sarah's going to get it. And then we've got only 5% that thinks it's John's children. Well, Mandy, am I glad that we asked this question, because guess what? Most of you missed it. Okay? It's going to be John's children. And you're looking at that and saying, whoa, wait a minute. The will said Millie, or the will said his wife. Well, here's the deal. Montana passed a statute that says a divorce revokes a bequest to a former spouse. So that's why Millie wouldn't get it. And of course, Sarah wouldn't receive it because she's the present wife. And the law went on to say that it's going to go down to the children. Now, if we had a friendly divorce and John did want to recognize Millie for all those years they had, what he needs to do is make sure that that will is then dated after the divorce decree. And then the will would be honored. Okay, so that's something to keep in mind. If you have a friend or a family member that is divorced, and without seeming snoopy, you can tell them that you attended this session and learned that a divorce revokes the amount to a former spouse. Now, really, that should have happened as far as writing a new will as soon as the divorce was done. The attorney should have said, we need to take one more step and do this. But maybe everybody was so traumatized at the time, you know, divorce is never easy. So they didn't get that done. Now, I had a lady at one of my meetings, and she had been divorced for 20 years from her spouse. I'm sorry, she's been separated. Did I say divorced? I mean separated. Okay. Well, she thought that because she separated, that her husband would not receive her estate. Surprise! He would. She could have that solely owned, and dies, and ta-da, he's going to receive it all. So keep that in mind. So let's look at this. This is just kind of a little trivia question from last week in a sense, but if the children are minors, what age do they receive their assets? So enter your answer in the chat room, and we will be able to see how many of you got this from last time. Although, Mandy, it makes me think, I wonder if we should ask in the beginning, how many are new people? Because we may have some new folks today that you wouldn't have heard that last year or last week. So we can certainly tell you that. So we've got that in the chat room, and Carrie will keep track of that. So I guess my parting words here are write a will and make sure that you have your property distributed according to your wishes, and that you're not the bane of somebody else's existence. Okay, we did that. What is the word devacy? Okay, so we know we've got that in there already. Oh, forget-me-nots. Mandy, I'm sure I'm supposed to not forget something, right? Well, no, it's the untold story of the bell. When my mom had passed away and dad was already gone, us kids are going through the house doing the who gets what, and here's a bell. And we're looking at that bell and we're looking at one another saying, where did that come from? None of us knew. And the bell has a date scratched on the inside, 1881. And that's probably significant for a reason, but we don't know what the reason is. And I think mom or dad, who knows, had the bell. And what's the story? It's it's an untold story of the bell. So, Mandy, I guess I would call the bell tangible personal property. And people would look at me cross-eyed and say, what's tangible personal property? So why don't you tell us that? What are some examples?
All right, so some examples on like in this list of things that people might have would be guns or tools that are either valuable or historic or important. I know we have a handsaw that was great grandpa's that's pretty treasured. Books, special dishes, linens and needlework, different collections, furniture, and wildflower photos. So this might be Marcia's list of her titled personal property. So anything that's special to you that you want to make sure gets passed on to other people. So I think it's important also to recognize that special objects, so these are going to serve as props for telling our family stories. They're also really important ways of connecting our family. So I brought two things from home to share with you guys today. So this, I don't know if you can see this, this is an Alabaster Pear. And this is joined by a lot of other fruits that sit in a bowl. And when my husband and his cousins were going through their grandma's house, it was funny, all of the cousins from all of the different families remembered this bowl of fruit. And it was really important to all of them because maybe they spent a lot of time where that was at their eye level in the kitchen. It always sat in the same place. I think as a kid, they're beautiful and smooth and maybe cool to the touch. So they were all really, really tied of all of the things, all of the candlesticks and dishes and beautiful furniture. They all were very, very tied to the fruit. And have passed that story on also so that even I know the story of the fruit bowl. I brought something else in to share from my family. So I don't know if you can see this little pot. It folds its handle over and was in my dad packed for the forest service. And so this was in his cookware. And inside of this little pot is this teapot that it's still, I haven't scrubbed it off. It was still in the camp boxes just like it was when we found it. And I'll just share this personal story. Of course, this wasn't included in my dad's tangible personal property. My sister collects teapots, and so we could have had a dispute over this cute little guy because I have memories of this teapot of us camping and hunting, and this is what we'd boil our tea water in or our coffee water in, and but also how cool for my sister to have her dad's teapot. So we were able to resolve that dispute, and I'm able to keep the teapot for now, and so that's worked out really well. But it could have been, I mean, how awful to have had a dispute over a little tiny tin teapot. However, our tangible personal property can be really connected. Other people can connect with it, and so it's good to have those conversations. And also, it's really good to make that list. So we'd like to share with you how to do that. And also, I just want to, on a more personal note, I want to encourage you to tell the stories so that, like Marcia said, you know, people know the story of the bell because then when they have the bell, it means something to them. So Montana law is going to require that you have a paragraph listing and stating that you have tangible personal property. And so that's going to let people know that you have this listing and that somebody didn't make it up, and it's included as a part of your will. So you also want to make sure that your listing is specific. So Marcia's given us an example here. So Grandma Ray's opal ring. So then we know which ring this is. It's not an opal ring that's stashed away somewhere, or a ring we've never seen before. Also the Montana sapphire ring. So that's very specific. That lets people know who you wish the item to go to, and also specifically what the item is. So then, and the ladle from 1847. So again, you're listing that property specifically. So, you know, this might have been the bowl of alabaster fruit, or the tea kettle as part of the camping set, which I brought that one because it'd be something nobody would ever probably think about. But a conversation also would have been a fun way to share those stories. We do have, Extension has a really good mock guide that goes through this. I loved Marcia's title for it, Who Gets Grandma's Yellow Pie Plate? Because isn't that often the place where we have the most passionate memories, is around those sorts of items, just like the teapot. And so I encourage you to check out the mock guide, and it'll be listed with all of the other resources on the website. And you can download it there.
Yeah, Mandy, I remember my grandma rolling out, you know, the rolling pin and making a pie, and there was always leftover dough. And she would spread some cinnamon on that dough, cinnamon sugar, and then cook it a little bit, and then us kids could eat it. And that's, I think, where I developed eating raw dough was from grandma, because it was really fun to taste that stuff.
Absolutely. So another tip from the Forget-Me-Nots is to have a photograph in your will, or a paragraph in your will, making sure that you're referring to your separate listing of tangible personal property. And then make sure that that listing is clear, so that people know exactly what you were talking about, and that your wishes are honored.
Well, and Mandy, I had one lady that as soon as she got her cell phone and discovered the camera part of it, she went around and took photographs of all the items. And she still has her separate listing, but she's also put that and made a notebook.
Nice.
And, you know, it's kind of neat for her to sit down, refresh her memory about the various things. And then my comment was, what's the story behind this? And as Mandy said, the story is part of it. It's not just a hunk of metal or an anvil or whatever it is. It's the memories that people attach to those things. So it's really neat to get involved with doing this.
And also, I guess, one thing I'd like to add is, it seems tedious, maybe a little bit tedious and kind of hard to think about, but it's such a gift to receive those stories with the items that you receive, either your own stories or that passed down story. So Marcia, what if a person has items in their safety deposit box and they want their minor children or grandchildren to be able to inherit those?
We may have a little bit of a challenge here. So I'm going to use the Jones Columbine to help explain this one, because it's Jack Jones. And what Jack Jones has is a coin collection. And he has put that in his safe deposit box. His brother, John, is a signer on that account. But in his separate listing, he's named his granddaughter, Susan Jones, to receive the coin collection. So right away, you can see that we've got a little bit of a dilemma here. We've got two people. And the idea is then, who is going to receive that coin collection? Is it going to be John, because he's a signer on the safe deposit box? Or is it going to be Susan, because she was listed as receiving the coin collection in the separate listing? So you get to vote on that one, either John or Susan, and think about your reason why you think it's going to be one or the other. And don't forget to hit the submit button. Okay, we've got 32% that say Susan, and we've got 9% that says that it's going to be John. So let's take a look at that situation, because we may have a family that's going to have some challenges. So when I first found out about this, I was writing the mock guide, and I was asking the attorneys. And what I had was 50% of the attorneys said it's John. I had 50% that said, well, it's Susan because of the separate listing. Well, as time goes on, we've got just a different kind of response, is that because John is not only the signer, he is the joint tenant on the box. That means anything in the box that's not titled becomes John's. Now, that is not what the grandfather wanted to do. And so I would just ask you, should your safe deposit box be in joint tenancy if you have some items in there that you want to go to someone whose name is not on that box? You see, we think that when we sign on a safe deposit box that we're just signing. You know, we don't own anything. But if you look in the small print of that signature, the card that they had or the piece of paper, you may discover that you are a joint tenant. And so I would ask you kids, I was one, when mom and dad wanted me to put their my name on their box, I said, oh, sure, no problem. Well, years later, it did become a problem, and I just couldn't believe that it would be, and you wouldn't believe it in your family either. So don't set up your family members for distrust or temptation or suspicion that you might be doing something a little funny, okay? So just think about it. Should your safe deposit box be in joint tenancy if you want to leave something that's in there, like the silver dollars, remember the $2 bills? Well, I got a couple of those in my safe deposit box. But you see my United States savings bonds with beneficiary designations, those don't count because there's a beneficiary designation on those. So Mandy, let's take an example of a parent, and what they've done is put a checking account in joint tenancy. And it's an older person, I can tell, because of the amount of money that was in there. My dad had this much money in his account, and his family economics daughter was having fits thinking about, oh my gosh, what if somebody got into that? But the idea is grandma's wanting to leave the property to a minor child.
All right. So let's talk about this a little bit. The joint tenancy between a parent and a child on financial accounts and a will, and different ways that we can do this. So so in this example, the owner of the account, mom, wants the daughter to take over paying her bills for her. And that makes sense. Is, you know, just to make sure everything's getting paid and everything's taken care of so she doesn't have to have that stress. So she has put her checking account in joint tenancy with the right of survivorship on her checking account with $80,000 in it. What her intention is that if she or when she passes away, that her granddaughters would inherit that money. But she wrote a will to divide that equally among her two granddaughters. So how do you think that the money would be divided? Is it going to all go to Susan because of the joint tenancy with right of survivorship? Is it going to go to Montana because of the conflict of the will, what her intentions in the will are versus the joint tenancy with right of survivorship? Is it going to be divided equally between Sarah's two granddaughters according to the will? Or are all of those answers wrong and none of that's going to happen? So what do you guys think in the poll question? Go ahead and put your answer in there and then make sure that you hit submit so that we can see them. right. Okay, so it looks like quite a few of you think that it's going to all go to Susan because of the joint tenancy with right of survivorship. And a few of you think that the will be honored. And then a couple people think that all of the answers are incorrect. So in fact, in this case, it will all go to Susan, the daughter. The joint tenancy with right of survivorship on the checking account will go to Susan, and the will have no effect. So the daughter Susan will get $80,000, and the two granddaughters will inherit nothing. Won't inherit any of that money. And then it is left to Susan to make that choice as to whether to honor the will or not. But legally, it doesn't go to the granddaughters. So in Montana law, joint tenancy with right of survivorship and real personal property takes precedence over a will. So it doesn't matter what you write in the will, it matters how those accounts are titled or that property is titled. Even if the will was written after the joint tenancy with right of survivorship. So, so this cool tool that I just learned about from Marcia is that in Montana, instead of, you don't have to change the ownership of the account, but you can use the private party account form, the multiple party account form, which is going to allow a designation. So it would allow you to make that person a signer on your account, but you're still the owner of the account. And they have no ownership rights of that account at death. So it's kind of like a power of attorney over the account, so they can use it while mom is living to pay her bills, but then it would be distributed according to the will. So if we looked at this example again, with a multiple party account without survivorship, Sarah's will would equally go to the granddaughters. So that might be a better way to go ahead and do that. So when you're writing your will and you're setting up your accounts, you need to decide whether joint tenancy or multiple party accounts without survivorship is the best, the best way to meet your estate planning needs. So you can think about those options, but it's good to know that you have those options. And also, mom can still get some help paying her bills or whatever that is. So there's lots of ways to go ahead and accomplish that. So Marcia, can you explain to us how the Montana Legal Developer Program might be able to help with a will?
Yeah, this is a program I didn't know about, and I'm using the Flame Lily from my last trip to Botswana before COVID. And get this, folks, be on fire to get your will written. Does that work? Okay, well, Mandy, sometimes you just have to stretch to appreciate the wording. Okay, moving along. The Senior and Long-Term Care Division at the Montana Department of Public Health and Human Services has this particular program. And you don't have to worry about copying down the phone number or the website because it's listed in the resource page. Carrie put that up so that you could print that out and make a call to those individuals. And they actually will visit with you about a free will. Now, there's some requirements. You must be age 60 or older if you're an adult with a disability, or if you're a tribal member over the age of 18, they have special funding that they can do to help you with a will. And they have an attorney on staff that would be working with you at the same time. So they also then, at their website, have forms that you can print out. And there's forms for single people. So there's an instructional information there, and then the form, and it has the basic things that are included in a will. Now, those of you that are married, they also have those forms for you. So husband would need to fill out one, and the wife would need to fill out one just exactly like it, expressing each wishes maybe separately. And so I took some of the information and I put it on slides, and I don't expect you to remember or be able to read all this, but I just wanted to feature some of the things that are in the will that might attract your attention. And then one of the things is an intro, and always you say, I hereby revoke all prior wills. I mean, I've had people come to meetings and they say, well, this is my will from 1954, and this is from 1964, and then this one's 1990. Which one is right? Well, it's supposed to be the last one, and you're supposed to destroy all the ones before it. And then, you know, you indicate if you're married, and there's an indication there, and then you put the names of your children. And then, of course, we want to be good citizens and make sure that all of our, any debts that we have, and I like the word they use in there, enforceable debts. In other words, okay, and those are going to be paid off. And then here's Mandy's tangible personal property list. There's the paragraph. And that's something to think about too. Are you going to leave it to your spouse and then have that spouse turn it over? Or there's some things, like Gary and I were talking, and I said, well, there's some things I want you to keep if you want to, and then distribute it. So we're still working on that part. And then look at this right of representation. Remember, we talked about that last week. What does right of representation mean? Well, there it is in the will. So we got to look at that. And I was going to show you again, but I knew we were going to run out of time. I want to be able to talk to our special guests. Personal representative, this is where you nominate it. So I have a couple of colleagues from the past that I would like to do that. Trouble is, we're all about the same age now, and I need to be thinking, I maybe need somebody younger, Mandy, younger. Okay, and then a guardian. And I noticed that that is in the will, but I did raise an issue with them because they're also not mentioning a conservator. And I see circumstances in families where you might want to have two different people. One's the guardian, the other's the conservator that handles the money. And then there's this attestation. And that's just saying, you know, I'm signing my name, I'm 18 years or older, and I'm not under undue influence. And of course, I'm of sound mind, although I forgot a program this morning where I was supposed to practice, so that may be questionable today. Then it's self-proven. You have some witnesses. So the witnesses are going to sign it, and then you're going to have the notary there who, well, you won't, but the attorney would. And they do this. Boy, it's just a great, great service that the Montana Legal Development Program offers. So my tip from the Flame Lily is do take advantage of the Legal Developer Wills program and look at those forums because they will be very helpful to you. Mandy, I think we're about out of time because I want to make sure that we have our guests. So I'm seeing the observation from our lady slipper last week. Time does slip away. And I hope we did steer you to important information about wills. I also hope we steered you to the free will that you can get from the Montana Legal Developer Program. And I also should mention, if you go to their website, they are now starting to do programs out in the community where you can sign up ahead of time. And then they send you the forms and you do with them what you want. And then you meet personally with the attorney. They call it pro bono service, free service from, not bono as in the old, forgive that. Anyway, it helps you, it helps you. See, I'm getting tongue-tied. So if you don't have a memory like this elephant's head, we do have those mock guides that are available, 50 of them. Whoa, 50 different ones. So I'm sure you'll find one in there that's a topic of interest. And don't forget, these are also available at your county extension office. Mandy has them, so does Kimberly, and so does Wendy. Take advantage of that. So I need to tell you the answers, and we use the testator in there. But a testator is a person who writes a will, and the devotee is the person who inherits property in a will.
Marcia, I have a quick question for you. So someone for this question said a person receiving benefit from an estate. Is that the correct answer or not?
No, it wouldn't.
Okay.
Oh, leave it in there. It's really, the will is the key. That's where when you're writing a will and you see that term devisee, like I did the first time, I go, what is that? I didn't know that that is a legal term for when you're doing the will. And then they refer to people as heirs, Heirs, if they died without writing a will and it passes to these, what I call beneficiaries. But beneficiaries is like life insurance where you name a beneficiary. So next week, we want you to join us once again. And what we are going to be talking about are revocable and testamentary trusts, which are ways that you can get out of that dilemma of, oh my gosh, my minor children or grandchildren inheriting property at age 18. We've got some excellent ideas for you. So I'm going to close out here, and Wendy and Kimberly are going to be joining us, I hope. And what we've got is Mandy asking them some questions. So close out, Marcia. Usually I have a trigger slide, but see, I remembered. That's pretty good. Okay. And go forth. Yes, I see him. Hi, guys. Welcome.
Thank you for joining us today, you guys, and taking a minute out of your busy schedules over lunch. And so we really appreciate it. And so I'd like to just start by asking you, each of you, to share, how did you get started planning your will? Where did you start? What did you do first? So Kimberly, do you want to go first?
Sure, I can. So basically, what really kind of prompted my process and moving forward is that we were blessed to have a little boy, and we don't think there are going to be any others. And right now I think at the end of the month, he will turn 5. And so really looking at that piece for him. But then the other real catalyst was that I unfortunately lost both of my parents and have had a hellacious inheritance battle with my sibling, because the will that was in place said it was, to be inherited by the 2 siblings 50-50 without any real provisions of what that looked like. And so it has created a giant disaster and has split the family. I choose not to speak to this person. I refuse to even call this person by their name. They are my sibling, and that is about it. And the court battle has continued. The 2 millennials have effectively pretty much, I would say, destroyed the family legacy in the sense of losing the farm and the ranch. And I know Marcia's probably discussed some of that, but that's what really prompted me and my significant other to really look at what that's going to look like. I kid around with my 5-year-old. I was like, this is why you're not having a sibling. This is why you have horses and cows and things like that, and dogs and cats, because we're not going to go down that road. But also the real big important thing for us was that as older parents, we were really concerned about who was going to take care of him in the case that something happened to us. And then we are also the guardians of my significant's mother, who has dementia, and what that would look like if either one of us was gone or left alone to handle that situation. And I will now be quiet and let Wendy add her piece in there.
Yeah, and thank you so much for sharing that perspective, Kimberly. So Wendy, I have the same question for you. Where did you start, and what prompted you to get started?
I'm in a little bit different position than Kimberly. I have a son who is 25, moving close to 26. But when he was younger, for me, it was very simple. Unlike Kimberly, I have no siblings, so I'm an only child, and my son is an only child. I think the one thing that probably sets me apart from her is within a short term after Logan being born, I did do a termination of parental rights from my ex-fiance because he was unwilling to participate in anything having to do with his son. So that was an important piece that I needed to do, both to protect me and to protect him from anything down the road. And that is still a document that I have put aside today, so that there won't be any problems that comes up with that. I kind of relied on a lot of luck and the fact that I knew that my parents would be there to take care of Logan and they would automatically get him if anything happened. So I had a holographic will written from an early time, which I don't remember if it was allowed in Idaho when we were there or not, but I do know it was allowed here in Montana. And because I don't have personal property other than a house or a car, everything was set up as a TOD or a POD, and he is the designated beneficiary. And we've also done some of that with my mother's and father's accounts. My father passed away a couple years ago, and he was very clear that Logan was to receive some of these accounts. And so all of that's been set up since his passing. And I think for me, it's been a little bit easier.
Thank you for sharing that perspective also. I think it's good to remember and good to note that different circumstances call the right answer. There's all of these options, and one is not right or wrong, just which one will get the job done in all of the different circumstances. So Wendy, I've asked you this before, but I was wondering if you would share it. Have you made any changes to anything in your will as Logan has gotten older? And also, how much does he know?
I really haven't made any changes as he's gotten older, other than now he is the beneficiary versus my mother. Originally, when he was a minor, he was to receive 50%. My mother was to receive 50%, and that would be for his care and upbringing. So now he's 100% the beneficiary on everything. And he is aware, with the passing of my father, there were a lot of things that happened that we went, these are good things to talk about. And so he is very familiar with where we are at. Like Kimberly, my mother has dementia, and so I'm her caregiver and have been taking care of her finances, paying her bills, as well as making decisions on any accounts that are how they're being managed, and making sure that the decisions being made with the brokers are in her best interest to maintain and to not lose. So we're kind of in this time frame now where we don't want her to lose money. So investments have changed from a more aggressive approach to a conservative approach, and it's kind of a blending. And Logan's very aware of all of that, because a couple things have happened as a result of that. One, he's become very aware of his own finances. And when he was very young, my dad started a stock account for him. And by the time he was 10, he was making his own decisions on how those funds were purchased or traded. And as a result, he turned that into a house payment. So his own personal interest became very vested. He has seen the results of taking different steps in how he manages his funds and has become very good because of that. So I think that having those conversations has been very important.
Awesome, thank you. And what a testament to like getting somebody started right off on the right track right away. That's fantastic.
Yeah.
So Kimberly, I have a question for you. I know that every process is different, but just a ballpark, I think one of the things that I was worried about when I was first getting ready to start writing a will was how much money, where do I start? Do I make an appointment with the attorney? How much is this going to cost me? Do I have enough to start? So do you want to share who you talk to and just a ballpark?
And like Wendy alluded to, there are many, many different circumstances, and all of the education that everybody's receiving on this series from Marcia, all of the planning and estate planning tools that Marcia has put into place are definitely things that can help you, especially if cost is an issue. Definitely utilize the resources, and have your documentation ready to go. And my advice, just given, Marcia gave a great example in today's presentation about, that joint safe deposit box. I mean, really being forward thinking about the people that you're leaving in charge. And with the situation that I've had, I mean, like I said, it's just really difficult, and you need to find somebody. It's hard because things change even in their lives. And so when you name these people, it becomes difficult. But my personal thing is based on what I dealt with my own family was, I need to have an attorney to do this. And so there are many, many different types of attorneys. There are some that will help you pro bono in the sense dependent upon what you make, but a lot of them work on an hourly, pay rate and sliding scale dependent upon what they're going to do for you. And the more complicated it gets, the more that price goes up. But I would say, I mean, definitely budget, just basic. If you're going to go the attorney, at least $200 an hour. That's usually like kind of the base of getting someone that really has an idea of what they're talking about. But then remember that's as you start adding in other details and other pieces, and then when you're working with another individual and all of their family pieces, it becomes, it can get very complicated. But I still think that, an attorney and the professionals, especially if you have a really complicated situation, accountant is another $100 or so, not as often. But I would say to begin with, I would say in the $1,200, $1,400 range. And then it can obviously significantly go up dependent upon what you're having those individuals do and what that discussion looks like.
And to what Kimberly has said, I would add, if you use the mock guides that Marcia's prepared for estate planning, you can significantly reduce that bill because you can come in prepared to answer questions or have the information already, and that will shorten the amount of time that it takes them to do it. But it also sets you up in a position where you're saying, these are the things how I want it to work out. The attorney's putting the legalese in the proper form so that there's no questions when it goes before a judge, if it has to say, yep, this is a valid will or this is a valid document, because it's the interpretation of it that can be a little bit sticky. So using the mock guides to understand your situation, identify how you want things to be distributed or shared, knowing which ones can be POD or TOD, so that you can avoid other problems with those accounts, can be an incredibly huge asset before you even go to the attorney.
Thank you both for excellent answers to kind of that's a big question. I know it's a big question, but I wanted to put it out there because I think sometimes we're afraid to start because we don't know where to start and if we can even afford to start. So great suggestions to use those mock guides and become a familiar. And then also thank you, Kimberly, for sharing kind of what that budget could look like also. So excellent. I want to ask too, Marcia, is there anything that we have missed or that you've thought of while we've been chatting that you want to jump in or ask? And I will check the chat.
You know me, I've always got a comment. And one of the things that both were talking about is the attorneys. And that's why I think you would be interested in our latest mock guide is selecting an estate planning attorney or handling probate. I forget the official title, but the idea is these are some questions to ask. These are some ideas for how do you find an attorney that is in the estate planning area. I mean, in our smaller communities, it's a challenge. If you only have one attorney in town, that means they do everything. And if they're county attorney also, they have all of that. And so in our larger communities, we do have attorneys that are able to specialize. And even though they wouldn't advertise that, they do spend the majority of their practice. And I know I was asking an attorney one day, I have just a typical question, what percentage of your time is spent in estate planning? And he told me 5. And I thought, no, that is not enough for me now. I need somebody that's going to do more than just a boilerplate will. Particularly when I was trying to provide for my folks. Mom had Alzheimer's. I wanted to make, and Dad had macular degeneration, so he couldn't see. And I wanted to make sure that if something happened to me, that they were going to be okay financially. So I told my hubby, sorry, you don't get anything, because I want it to be for them and for their care. So there's, we've really touched on some things that are important, and I agree. Thank you, Wendy, and thank you, Kimberly. It's so great to hear those personal stories. And I thank you for putting yourself out there to share that. And my experience with cost was kind of a little overwhelming because I kind of thought I knew what I was doing, and gee, it ought to be cheap. And, you know, $800 later for a will, I'm going, oh my gosh. But it gave me such peace of mind that I could travel the roads of Montana, and if I was killed, everything's in order. And I also thought how embarrassed I'd be if, you know, the newspapers would read, Marcia Getting did not practice what she preaches. So I want to make sure that I have all that done. Well,
Good
Carrie,
motivation, Marcia.
yeah, Carrie, how about some questions? Do we have any that we need to answer from our participants? Because we said we'd be glad to hang around for another 15 minutes, and maybe our two guests would have some answers as well.
Marcia, we don't have any questions right now.
No
No,
questions.
not at the moment.
Oh,
Yeah,
not a
there's
one.
actually two. This is Wendy. There's actually two. Jay has
Okay.
asked, if I'm named as a personal representative in a will, am I obligated to perform, or what do I have to do? And then he has a second part to that question, but if you want to answer the first one, I'll get into the second one at your wish.
Oh, thank you, because I can't remember two questions at one time. So we're talking about nominating the personal representative in our will, and 99.9% of the time, the district judge is going to go along with that. And one of the mock guides that we have is probate, personal representative responsibilities. And we have a long list of all the different kinds of things that a personal representative needs to do. Accompanying that would be our one on probate, because that would allow you as the personal representative to say, oh, am I going to do a formal probate, informal, summary administrative procedure, collection of personal property by affidavit, and things like that. So like Wendy says, our mod guides can save you money because we're giving you information that you need to do or have before you go in and sit there and see dollar signs rolling across as you're asking questions of the attorney. A lot of those things are in the mod guides because these are questions that people have asked me through the years. So did I answer part one? Okay.
Waiting for a response. So the second part to that question that I'm seeing is related to the previous question. This is also from Jay. Does merely being named a personal representative in a will give me any powers to manage assets like closing bank accounts, selling real property of the decedent, etc.?
Yeah, and that's the duty of the personal representative. Now, you just can't go out there and start doing it. What you've got to do is, if you have a copy of the will that shows that you were nominated as a personal representative or the original will, you must wait 5 days before you submit that to the district court. Okay, so you go to the clerk of the court and you give the will. And there may be some questions. How do you think you want to handle this, etc. And then you get a letter of appointment. And once you get that letter of appointment, then you can close the accounts. You can determine if we're going to sell the house. You are stepping into the shoes of the person that has died. And you may not know everything there is to know. And I would hope that the person that nominated you as personal representative gave you a little bit of information about what's going on. But if not, you know, you may end up saying, you know, I can't do this on my own. I've got to have an attorney assist me with going through the steps. And so if you are going to hire an attorney, ask the rate per hour. No longer is the fee for the attorney based on a percentage of the estate. It used to be 3% of the first 40 grand and 2% after that. Now it's reasonable. And I have difficulty with that term, but that's what the law says. So you've got to encourage the attorney to keep track of, you know, the number of hours. That's what you want to see, so that you know this is the service that's being provided. And maybe it's just a couple of pieces of paper. You know, we're going to change the deed from the husband's name to the wife's name. Well, we've got a property joint tenancy Mont guide that shows how you can do that because the legislature included that in the law. But if you don't feel comfortable doing it, that's where you go to the attorney and say, hey, this legal stuff, you know, I know plumbing, but I don't know how to do these things. Okay? Any
Marcia?
other questions?
There is another question here. How much can you charge for being a personal representative?
Oh, your fee must be reasonable as well. So you don't get a percentage of the estate either. So I've talked to the attorneys about this, and they're saying here's kind of what they had in mind when the law was submitted, is that if you're doing bookkeeping kinds of things as a personal representative, you want to keep track of the hours that you're spending doing it. So that's a responsibility, just in case you were ever asked by the district judge, how do you justify your fee? And the attorney would need to be the same way. How can you justify your fee? So you got to track it. I'm sorry, it's one of those things that needs to be done. Okay, today I went to the courthouse, blah, blah. Then I had to write a bunch of letters. Oh, gee, I went to the newspaper so that they can print the notice to creditors. Okay, that has to be published 3 times. And so there's all of these details. But, you know, I don't think you would get by with charging $600 an hour. You know, you may be very valuable, so it's got to be reasonable. And if there's some heirs involved, they're going to be sort of watching what you do and tracking some of that. And so just think, if I had to justify what I'm charging, how would I go about doing that? And that kind of answers the question there.
Okay, here's another question. Are there any challenges with designating a guardian or conservator for children who are not a U.S. citizen or do not reside in the U.S.?
Oh, give me that one again.
Are there any challenges with designating a guardian or conservator for children who are not a U.S. citizen and does not reside in the U.S.?
Okay, that's one of those. You're going to nominate the guardian in the will, and there is no requirement under Montana law that they be a U.S. citizen. Same way with naming a personal representative. They don't have to be located in the town, in the state, or even in the country. They can be out of country. But the guardian, you nominate, and the judge will make the determination. And it could be there's reasons, and people would come forth and say, no, this person that's out of the country shouldn't be able to do it because of blah, blah. You know, maybe they're an alcoholic, maybe they're in jail or something like that. But unless there's really just cause, the judge will probably go ahead and say, yes, this is the person. And of course, that person needs to agree, yes, I will be the guardian. See, you can nominate somebody, but it doesn't mean they have to say yes. I mean, if my sister had nominated me as a guardian instead of a conservator, I would have had to say, there's other people out there that would be better because they're, you know, located. And that's the thing. You want somebody close to your age to take care of those kids, probably, not grandma and grandpa. Now, in Wendy's case, it would have worked just fine. But there's others where this set of grandparents and this set of grandparents get in there and they go like this. And what we've got is a court case. And there's losers from the perspective of a family that didn't win, and those hard feelings that Kimberly was talking about that happen. Yeah, that can be generational because the story gets told time after time again.
Here's another question, Marcia. How long does it normally take to get a letter of appointment once the will is submitted?
Okay, anybody want to take that one on? Usually it doesn't take that long.
Depends.
Yeah, okay, go ahead,
It
Kimberly.
really, so in my experience, you know, and I had all of these things with my folks' estate. And so I was the personal representative when that will was being written. They offered my sibling the opportunity and he declined. And so then I was the personal representative. I bet the way things have turned out, he would have liked to have changed his decision at that point, I'm sure, but once it's done, it's done. And I received those. I mean, ours was, putting in all of you have to make sure things are in order. And my parents' estate was extremely complicated, multi-million-dollar property with multiple ranch business. And so probably a whole lot more complicated than most folks are. So ours took a little bit more time, but you have to have the death certificates in order. You have to have make sure you have all of those papers, lined up that says you are the personal representative. I actually had an attorney help me because this was way above what my base knowledge was as far as how to handle the estate. And so I needed their help on because of the amount of money that was involved, because of a business on top of it, and then looking at that piece. And so I want to say it probably was about, I want to say like 3 weeks before I got mine, so that then I could start going down the channels of taking that and sharing that with the trust company, with the banks, with everything like that. So I think with less complicated situations, it may be, like a week or so turnaround.
Yeah, and sometimes it could even be the same day, because it's just, nobody anticipates any kind of problems. And like Wendy, if you're the only child and you're nominated as personal representative, it's not like there's other siblings that are going to say, well, it should be me, because all the siblings have the equal opportunity, but the spouse is before. Now, if you've nominated somebody, hey, that's pretty much a given, and it should happen really quickly. And maybe a free advertisement here, if you don't mind. We are running a series that we're calling Fabulous Fridays. And Fabulous Fridays, tomorrow's topic is my loved one has died, or I think passed away. We try to be nice. What do I do now? So I've got Kim Woodring, who is the extension agent in Tuke County, that will be joining me for Fabulous Friday. So we invite you, if you'd like some more information, to join us at 10 o'clock. And if you say, well, where do you register? How do you do it? Just put in your browser, Fabulous Fridays, Montana, and it'll come right up and you can register and we'll see you there.
I put it in the chat window also.
Oh, good, good. Okay, thank you.
Hey, Marcia,
Anything else?
Yeah, this is Wendy again. Can I add one more thing that really
you
came
can.
to be kind of a benefit? So as a result of all these conversations I've had with my son, it has also benefited him because earlier last year, or middle of the year last year, he decided to go off and work in Antarctica. As a result of that, he also has assets that needed to be taken care of. So before he left, he did a power of attorney. He also did a holographic will, because he's very clear. He said, I've got this money and I want it to go in this way to some dear friends of mine who are working on getting a business started and have school loans. And I would like to set up a scholarship at my college where I went, and I would like these other things done, and then whatever's left, you can decide what you want to do with it. So it really was a good thing to be able to have all these conversations these last couple of years, because of my dad's death and my mother's dementia, because it's put him on a track of understanding how important all of these decisions are. And he's 10,000 miles away. And if something happens, I've got one line that I can get a hold of him on. So having all those conversations even before he left sets him up in a good position, so that at some point when he does decide to settle down, whenever that may be, he can carry that on with his own spouse and then with his own children. So I think laying that groundwork early has benefited all of us. And my folks were pretty open and honest in terms of in their later life what they wanted to have happen. And so there are long-lasting benefits that can come from having these estate planning questions or conversations, especially as your children enter high school and college, and to kind of keep that out there. Plus, it kind of might set the tone to say, this is how we're doing it, and if you argue, we will change that so that it's different.
Okay. Well, Kimberly, any last parting words of wisdom?
There is a question that I think is kind of important too, also
Okay.
to go ahead and answer. So sorry to cut in, Kimberly, and we'll make sure that you also have a chance to have any words, but this one seems important. So the participant asked about, they have young children and want to make sure that they go to the guardian that they have nominated, and that person isn't a family member or their spouse's family member. So they're asking for some suggestions about how to communicate this to their family members, or is that something that you just don't communicate but have it in your will, and then just let them find out at that time? So what advice do the panelists, or Marcia, what advice do you guys have?
Boy,
One-
that one is a bit of a doozy of a question, because I can understand that the concern, and I've seen it happen both ways, where we've got the families that decided to tell the other family members, and then the other family members were getting very upset because they named his family instead of her family. And so one way to get around that is I would encourage people to think about successor guardians as well as conservators. So yeah, we're going to name these people right now. But if those people do not accept it, they get divorced, there's other things that happen, we've got the successors here. And that's one of those things, that your family better than any of us would. And what potential consequences do you think would happen as a result of that? So that's one aspect. The other aspect is it's your decision. You are the one in charge of your life. Well, at least we like to think we are. And you can make that decision. You and your spouse have talked it over. You have reached that agreement. And you say, this is what we want now. Now, 5 years from now, it may be different than that. And leave yourself the opening to be able to revisit that conversation again and see if those indeed are the people that you wanted. Sometimes friends don't turn out to be like you thought. But I know of one case where the woman did say, I want these people to raise my son if something happens. Well, she died as a result of an accident, and her parents went to court and fought and fought and fought to get that child. But it was the guardian that was named in the will that got permission to raise the child. So you don't know which way the court's going to go. So you can't really take away their right. But again, 99.9% of the time, the judge goes with the nomination. So keep that in mind.
And considerations in terms of a minor child, you may be a long way from home. I mean, when my son was small, I was in Idaho, but my parents are very close with me and him. And so that wasn't an issue. But if I had been a long ways away, it could well be that there were family or friends who were much closer to him and had a better understanding of him and his routine or our routine, as he may have been ensconced in school or many other things going on, where it would have been a much easier transition if I died and he was with very close friends than it would have been to uproot him and move him far, far away. So, and then that evaluation of 5 years from now, is this going to be the same situation? Do we still have the same friendships? And making sure that you keep that current, especially as they age out of preschool into early school, into finishing high school, or whatever the situation happens to be. Because ultimately, I think as a parent, our goal is to make sure that our children are safe, well taken care of, and have opportunities that we would have liked them to have.
And I would answer to the person that asked the question is that, I mean, I think you need to have, you're going to know your family members or those folks that you didn't choose as your guardianship. You need to address that, that communication in the best way that's going to make it, livable. So for an example, like none of our guardians or our conservator for our child are family members. They're all outside. And we communicated that because we want folks to know that in the case this happens, you're not going to come and do this to our child. We want that seamless transition of this is who we've named. We have 5 of them, 5 different individuals and couples, if you will, because we looked at the stages and the ages for our child. And when, you know, between had he been an infant to 5, this couple was really great. Is now that he's 6 to 11, you know, they have, you know, similar children. We think that this one for the middle school, et cetera, et cetera. So we broke it down based on the ages. And then these folks would be really great at, you know, raising a teenager because they do this and this, and we really like this. And so, you know, keeping in mind that it doesn't have to be a family member, but I think having that communication of, hey, this is who we chose and this is why we went this way is really valid. But again, you have to navigate that on how your family, if you left out family members like parents, how they're going to interpret that. And I think if you can be as open and honest with them, you know, when the time comes, maybe now when you first have it written is not the time. And then I think also being, you know, really conscious of, yes, you have this in the will, but if it's going to break your mother's heart, you know, maybe she doesn't need to know because maybe your kids, you know, you won't have to put this into place. And then they would have never known that they weren't mentioned, and you can continue to maintain those relationships because you know, I think one of the big, and this is going to segue into my take home, is that definitely don't wait there. So with my particular situation, I never imagined I would be the personal representative without being known. My dad got a pulmonary embolism. One minute he was fine and the next minute he was gone. And so we had lost my mom previous and we knew that was coming. But with my dad, it was like one day I'm here, the next day I'm gone. And I didn't have any time to transition. There was no like, oh, here's what I should have asked or could have asked or should have done. And how did you foresee this? So I think the real important message, and I think Marcia had alluded to that too, is like, yes, this topic, this is a really difficult topic to talk with families, friends, loved ones. All of this is difficult, but don't make it the bane of your existence when it's too late. Try to navigate that bane and try to make it present so that you can have that peace of mind of like, yes, my son, and that's the way that I look at it for myself, is like, I don't want my son to go through what I had to go through, destroy families on both sides, to be able to just get something that should have just been relatively smooth transition. I want him to be able to transition smoothly in all of his stages. And then when he becomes an adult, be able to do the same things for his family. So again, don't wait, start the conversation. I think the conversation is the hardest part of it all. Figure out a time, figure out a place. Sometimes having a mediator that's either a good family friend or one of these professionals, an attorney, is a great person to kind of be that sounding board, especially if you have the idea that it can turn contentious.
Okay, well, again, we want to thank everybody for joining us, and thanks to our special guests, and thank you, Mandy. Great job today. I learned a lot and I appreciate that. So we hope you'll all be able to join us again next week when we're going to start looking at revocable living. No, I shouldn't say living, revocable trusts and testamentary trusts. See you then. In the meantime, be safe and keep healthy. All righty. Bye.